Part 2 of marriage. Green card based on marriage. How do you go about those green card based on marriage? First of all, it's advisable for you to have an immigration attorney, qualified immigration attorney for guidance. What exactly are they gonna do? They're gonna guide you through the process. They're gonna fill out those petitions, file those petitions, represent you for that type of proceedings, and help you with the interview process, and really just look at the document, the validity of those documents, and advise you accordingly. Because you don't want to make small mistakes that will lead to some type of denial or something else. Okay? This person gets in the United States with a French passport because they're French. They can stay here for 90 days because of this Easter type of program. And then the person gets into a marriage. According to the person, this is not a fraudulent marriage. It's just a marriage because USCIS, it's a good faith marriage, of course, and USCIS gave their how do you call it, conditional green card. At the time of removing conditional green card, the person had already filed for divorce. Unfortunately for the client, she was never advised on you have to remove condition. She thought, I guess because she got a divorce lawyer who is not an immigration lawyer, but basically they just handle divorce. She got divorced. She thought that that's it. I got divorced. I can marry somebody else. But she forgot to understand that when you file a green card based on marriage, you have to go with the process until the end. So when it was time for her to remove conditions, she wasn't aware of the fact that she has to remove conditions on time. And if she's no longer married, she has to say why she's not filing jointly. She didn't do all that. And the case was denied because nobody, first of all, appeared at the interview of removing condition. Nobody filed anything. And the case was referred to court. And she failed to appear in court as well because according to her, she never received a notice to appear. But if you look at the FOIA, it shows that the notice to appear was actually sent. So if she has a claim about not receiving, that's not with the court because the court has proof it was sent and it just showed that it was sent. What she has to do, if she had a lawyer, which it looks like she had a lawyer, she can file a claim of ineffective assistance of counsel because, you know, she never received that notice to appear. Or she was never advised on how to remove conditions, something around those lines. But, you know, if you want to go with that test of ineffective assistance of counsel, there's a lot of things you have to prove, okay? You have to prove that, first of all, what type of agreement you had, what the lawyer was supposed to do. Did you contact the lawyer to try to remedy that situation? What was this, the lawyer response? And did you file a complaint with the bar? Those three tests. And if you didn't do all three, why not? So in order to have a valid claim, those are the procedure that you have to follow, which is really difficult to win those ineffective assistance claim if you did not follow those steps. But anyway, so this person now, then they get married again the second time. First of all, they don't know that they're being ordered removed in absentia because they didn't show up. Now they get married, they file I-130. I-130 was approved without interview for some reason, I don't know. But then they filed for the green card. Of course, the green card is going to be denied because of lack of jurisdiction. Meanwhile, while they're filing for I-130, the girl was basically not in good terms with the second husband. She didn't file for divorce, she just left, took off, and went back to France while the case was pending. And because they didn't call them for the interview, the case was approved without the interview, the I-130. And now she found a job here in America. She's calling the lawyer now, trying to figure out, am I gonna come back? Oh, I need my work visa within 30 days. Can you make it possible? I'm like, listen, first of all, you've been ordered removed in absentia. And second of all, you self-deport. And third of all, you have a bar attached to that removal order and your self-deportation. So basically, technically, you have 10 years of bar. Now we have to find out whether the first marriage was fraudulent or why you failed to remove conditions. According to the client, well, I failed because I was divorced, I wasn't advised, etc., etc. That's not a big deal because there's nothing fraudulent about it, right? But the second big thing is the fact that you already been ordered removed. You have a 10 years bar. How are you going to come on a non-immigrant visa? You have to file for permission to reapply because the 10 years hasn't passed. And if it's granted, then you're going to file a non-immigrant visa. You can file both at the same time or separately. And once it gets granted, that's when you're going to come, because you want to come on a work visa. Chances are she might get it granted because she has already stayed 5 years outside of the country. It's like half of Ben has been, basically consumed. And then now that she has a job, and if she shows that the job is for the best interest of this government, because she's going to be working for some type of organization that has to do with the government, U.S. government, she has a little bit more chance because of it's the best interest of the government. No prior criminal record. We just have to find out whether the first marriage was fraudulent or not. It looks like it wasn't, based on the fact that she wasn't aware that she was supposed to basically to remove conditions. She wasn't advised. She thought because she's divorced, the case is off, done. So those are the explanations we have to really provide, including the waiver and stuff like that, and hope that the permission to reapply by filing the form 212 get approved, right? That's the only way. Otherwise, you have to wait for the 10 years bar because been ordered removed in absentia, because you cannot claim failure to receive notice to appear, because the court will show that you were served properly to your attorney. Maybe a claim of ineffective assistance of counsel could be possible, but again, gotta follow those prompts as described in the matter of Loresdo. Yeah, I don't know how to pronounce that name, but there's a framework on how to go about filing a claim of ineffective assistance of counsel in the context of immigration law. So that's it, right? We're talking about marriage. It's so important to have guidance. It can be a simple case. It can lead into disaster just for lack of counseling. People usually think that because it's marriage, it's valid. I can just file and get it right. But look at this person. Just because she didn't know she has to remove condition, and she got order removed in absentia. Can you imagine with a valid marriage, you end up with an order of removal? Yeah, you need real guidance. Qualifying attorney. You really need just guidance to the process. It's really important to do it, because right now, if let's say the person was claiming, I don't have the money for the lawyer, but now that you are outside and you have a better job and you can come back, so $5,000 back then, what is it going to do for you now? You see, that's how people are supposed to think. But we're here to advise because not everybody will think the right way, right? So that's why we have advisors to help out. Anyway, this is it for this video. We are still going to be continuing with a series of adjustment of status applications, and why not? Why should I not do it this way? Why should I do it this way? What to do in removal proceedings. When I'm done with that, those adjustment of status videos, then I'm gonna talk about employment-based and investment videos, investment visas. This is it for today. Thank you very much. Until next time, bye-bye.